Good afternoon, ladies and gentlemen, fellow Australians. This is the People's Media release. I'm hoping I can get this up on YouTube. I'm banned on Facebook for nearly another 3 weeks, and YouTube has banned me, but regardless. I do want to get some messages out there. I handed out paperwork at a couple of our gatherings regarding fines. So I just want to sort of go over that a little bit of how to deal with any fines that you are being given. So you can download these from Aussie Patriots Roll, and I'm also going to get them uploaded to makeaustraliahealthyagain.org, which is where we are also asking people to please join our class action in the High Courts against all breaches of our Constitution, shall I say, so all constitutional issues. Some of those being forced or coerced vaccines, coming under Section 5123A of the Constitution, border closure, coming under Section 92, and the quarantine is Section 51.9. Better double check that. Now, the notices that I handed out to people to deal with fines is basically just they were notices to the Register of the Magistrates Office, and needless to say, because these are constitutional matters that we are raising, you also need to send a copy to the Attorney General. So some of the things that we covered in this, for example, were for the fines, the notice of constitutional defence to charges. So the powers exercised by the Chief Health Officer, this is Victoria, each state will have correlating acts for each of the states, but regardless, yours will be the same. So the powers exercised by the Chief Health Officer, Victoria, State Emergency Powers and the Public Health and Wellbeing Act 2008 Victoria, excuse me, are constitutionally invalid pursuant to Section 51.9, quarantine, Section 51.23A, Section 69, 92 and 76. As a result of this, we're now going to build a constitutional defence. So I won't go any further with that. The rest of that information is within these notices. The courts in this country, as other judges, they are all bound by the Constitution. So I'll read you Clause 5 of the Constitution, which is operation of the Constitution and laws. This Act and all laws made by the Parliament of the Commonwealth under the Constitution shall be binding on the courts, judges and people of every state and of every part of the Commonwealth, notwithstanding anything in the laws of any state, and the laws of the Commonwealth shall be in force on all British ships, the Queen's ships of war, etc., etc. Now, furthermore, Section 106 of the Constitution only allows for the continuation of state constitutions subject to the Constitution. So Section 106 of the Constitution states it is saving of constitutions. The Constitution of each state of the Commonwealth shall, subject to this Constitution, that's the important words there, subject to this Constitution, as at the establishment of the Commonwealth or as at the admission or establishment of the state, as the case may be, until altered in accordance with the Constitution of the state. The important line there is that the Constitution of each state of the Commonwealth shall, subject to this Constitution. So what else do I want to take from these? Just a little note. So we have got what is known as judge qua judge, or we have got judges acting as persona designata. So the High Court has made it clear that a judge may act in one or two capacities, either exercising judicial power as a judge qua judge, or in their private capacity as a persona designata of no judicial authority. So these are important things that we the people need to know. There's lots of supporting case law for this. Hilton versus Wells, 1985, in paragraph 11, and Justice Galdron at paragraph 16, in Cable versus DPP, 1996. So I'll just read you out a quote from Justice McHugh. Another reason for adhering to a strict application of settled principle is that when a function is entrusted to a judge by reference to his judicial office, the legislators and the community are entitled to expect that he will perform the function in that capacity. To the intelligent observer, unversed in what Justice Dixon accurately described and emphatically rejected as distinctions without differences, it would come as a surprise, and this will be a surprise to most people, to learn that a judge who is appointed to carry out a function by reference to his judicial office and who carries it out in his court with the assistance of his staff, services and facilities is not acting as a judge at all, but as a private individual. Such an observer might well think with some degree of justification that it is all an elaborate charade, and that is exactly what it is. We've got to stand up, people. Keep saying that. We've got to stand up for our rights, and we've got to make sure that the courts and the judges are adhering to the law. So that was just a little bit from the notices. I need to importantly get out to people. I've had replies from Fines Victoria regarding my ridiculous fines. And I have sent off the notice to the Register of the Magistrates Court, and I have also sent off my notices to the Attorney General. So they are just responding by sending reminder notice, increasing the penalty, etc. So what I'm going to ask people to do, please, and don't fall for the charade. They're just going to continue with the bullshit because it is all BS. What I want you to do with your fines is I want you to find out who the prosecutor of the case is. So whoever has filled out that fine for you, find out who the prosecutor is. So if there is not one appointed, you can just address it to the Department of Public Prosecutions as a whole. So what you need to ask them is to please provide and produce a certified copy of a biosecurity control order that has been issued against you. You can also advise them that if they proceed to court as the prosecutor, and as they are now aware of the aforementioned, without the biosecurity control order, the prosecutor is knowingly engaging in an act of prosecutorial, big word, misconduct. That's a crime. So get the names, and as I said, if you don't have a name of the prosecutor or the officer on there, or if it's illegible, just send it out to the Department of Public Prosecutions as a whole. The onus is on them. That's an old maxim in law too. He who maketh the claim beareth the burden of proof. You're going to give me fines for things, you provide me the proof. Where is my control order? So that is going to be an interesting one. Oh, that's all I'll do for today. I think that I will take care, people. Stand your ground. And I will see you at one of the next gatherings. Hopefully I shall get this up. Love, light, peace, and everyone, we shall fight this system. Please go to Maha which is makeaustraliahealthyagain.org. Please join us in our class action. And we are also asking anybody who has been directly affected. So if you are being forced or coerced into getting a vaccine or a COVID test to retain your employment, to commence new employment, if you are being told that your child needs a vaccine to go to kindergarten or attend school. I do know of several people who have been forced to get the COVID test prior to having operations. This is absolutely disgusting. I did dig up something from Kerry Mullis. As we know, Kerry Mullis is the inventor of the PCR tests, and he has categorically stated that they are never to be used for testing for infectious disease. They are harvesting DNA. We've got to join the dots, people, we really do. Anastasia Palaszczuk's father, I think he's CEO of a company that is involved with DNA collection. It's like, come on. The more you join the dots, the worse it gets. Our media have shares in vaccine companies, and so do a lot of our politicians. We've got to get this country back on track, people. So, take care. Love and light.